be glad to do it. And when she told me her name was Blessing, I said to myself, oh, how good God is. And so, with further ado, I want to introduce Attorney Blessing. Is it on? Oh, let me say one thing. If you have a question, I want to try to get to you to give you the mic so that everybody can hear your question. And when she get an answer, everybody can hear it so everybody can benefit. So I'll be running a little bit, but y'all give me an opportunity. Thank you.
Good morning, everyone. Can you all hear me? Well, okay. Thank you so much for allowing me to be here. It's an honor to be able to come here and give this information. Um, I come from, and we'll get a little bit into my background, but I come from immigrant parents, and one thing that I see prevalent in my community is the breakdown of family due to loss. Um, that's because there's this mindset that I don't need to set up what's going to happen after I die. I mean, there's four of y'all can split it and we good. It's not a big deal. Or in my case, with Nigerians, specifically I'm Igbo, and within our ethnic group or tribe, we have specific customs and laws that govern the distribution of assets after the person passes away. And although those laws, those traditional laws rule in Nigeria, they mean nothing when you come in America. So I wanted to name this, I named it Peace of Mind Planning, but really it's about securing a legacy. And when we think of legacy, we often think of wealth, but I want to challenge that and say this is about really securing a legacy of love. And what you're leaving behind when you pass away. Um, like they say, death and taxes, those are inevitable. They're going to happen. They're going to be there. And so shying away from the conversation doesn't change the fact that when you pass away, something has to be done with your assets. And the question is, do you want when you pass away your family to be able to spend the time grieving you and the legacy you left of love, or spend their time bickering and arguing and distressed about, okay, what are we supposed to do? What happened? And this happens before you pass away. I was saying earlier that a lot of people want to wait until they're of older age to start thinking about estate planning, but this is something you should really think about as soon as you have a child. Because the reality is, you're blessed if you make it this far. It is not guaranteed. Um, so let's get into the slides. So, um, little disclaimer: this information is not legal advice. I still do recommend it. Ultimately, you talk to an attorney about your specific situation. Um, and don't just base your actions off of what information I give you. This is more so for educational purposes and really to push you to make the moves necessary to leave that legacy. So my name is Blessing Ananti. Blessing is my real first name. I'm born and raised here in Dallas, but I am the child of immigrants from Nigeria. I am the first person in my immediate and extended family to be born in America, and so I am a first generation American. Um, I grew up in Dallas near Harry Hines, and we grew up extremely poor. When I say extremely poor, I mean when my mom was pregnant with me, she didn't have a mattress to sleep on. When they came to this country, they came with nothing, and as a child growing up, we lived in apartments with roaches, rats, all kinds of crime. I watched my parents work and struggle to be able to bring us out of that poverty and bring us into a place of abundance, to where my mother and father were able to pay out of pocket for my brother to go to pharmacy school, where they were able to support me as I entered into law school, and my sister pharmacy school, and all the other children. Um, and so kind of, a pit to palace situation. And when we think of that story of Joshua, am I wrong? Pit to the palace, Joshua? Anybody? Joseph, thank you. I was like, it's a J. When we think of the story of Joseph, we often think about, and we hear, from the pit to the palace. We often think of that one life, how he himself went from being in that pit where he was placed to being in the palace on the right hand of the king, or the Pharaoh, I believe. However, that pit to palace is really about generations, how one family can start from one place, and based off of the decisions of each individual, their habits, their mindset, and intentionality, make it to the palace. And that palace is, ultimate palace we're trying to get to is heaven. But at least here, while we're here on earth, we're hoping to live in abundance. We're hoping to live a life of security, and where we have our basic necessities, and we're able to guarantee future generations to have the same. So, what is estate planning? Oh, I went too far. Okay, so it's important to know that in the United States, 64% of individuals die without any estate plan. And some people, it doesn't really matter how educated, uneducated, how rich, or how poor you are. Here's a list of some individuals who did fail to plan: Abraham Lincoln, Jimi Hendrix, Dr. Martin Luther King, Aretha Franklin, and as of recent, Chadwick Boseman. These are people who died without any estate plan, resulting in their families being in court. So I'm here to challenge you not to be part of that 64%, to make different decisions so your family isn't in court. So what is estate planning? It's essentially just a plan that addresses what of yours goes to who. How are your things managed? What are the decisions that are made? You are giving instructions for not just your life, but your legacy. And the reason I say life is it's important to know that there are many estate planning documents that are used, not just those that are used when you pass away. We have, for instance, a financial power of attorney. This is something that you actually can set up now to say, hey, I give my daughter the rights to make financial decisions on my behalf now while I'm alive. I'm busy doing X, Y, and Z. I don't want to be bothered with it. I want her to do it now. Or you can have a springing financial power of attorney that says, if anything happens to me where I am no longer able to think for myself, I no longer have capacity, which is a word that we use a lot in the law, then I want this person to be able to make all my financial decisions. This is the person I want the mortgage company to talk to. This is the person I want to be able to handle my bank accounts. This is the person who I want to be able to handle my Social Security, my veteran benefits, my Medicare, whatever financial things that you have. This is an important document you use to set up who is your financial power of attorney. And to give a little more specification, there's a general one and a limited. General says, I give them the right to make any decision. They can make any decision whatsoever regarding to my finance. Limited says, I give them the right to make decisions specifically about X, Y, and Z. About my home. I give them the right to make financial decisions regarding my vehicle. I give them the right to make financial decisions regarding certain things.
So does the power, the power, see, it's saying, so there's different power of attorney. This is something different than the power of attorney to make decisions about health, right?
Correct. Okay. That is correct. So this is different from a healthcare power of attorney. And a healthcare power of attorney essentially is saying, this is the person who gets to make the medical decisions for me. And if I'm incapacitated, I'm unable to communicate, I am laying in that bed in the hospital. This is who makes the decision. Here's the person who is able to say, she does get that blood transfusion. She does get that life-saving surgery. No, actually, I don't want her to do X, Y, and Z. But it gets a little more You're fine. It gets a little more, this isn't the only healthcare document that is important. I say this is a good one to have in case of, let's say you're unconscious in an ambulance, God forbid, but they need to know whether or not they can give you penicillin or X, Y, and Z. You don't have it marked on your driver's license like you should. Okay, who's the person who's going to tell them, hey, she can't do this, she can't take this, she's not allowed to have this. These are the things that you shouldn't do. Go ahead.
Okay, I wanted to ask, you said there was a financial power of attorney and a springing one. What about the durable power of attorney? Because I have one, and I thought that it covered like everything, like you said, in the general.
That is correct. So durable power of attorney covers,
Let me switch. This one seems to be a little louder than that.
it might, oh, okay. I was going to say it might just be me. So a durable power of attorney does the same thing. Only reason I specify financial is because sometimes people will get durable powers of attorney and believe that they also cover all the healthcare aspects. And technically, you can have it all in one document, but you have to make sure you specify. Right. And that's the issue with a lot of self-help options. People will either give too many rights to people in the document, or they won't give enough. And so it's important to know what powers you're giving to someone.
Can you explain a little bit more about, so if there's a healthcare power of attorney and there's a financial power of attorney, and then there was another one.
She spoke about durable power of attorney, which is just a general power of attorney that can convey all of the rights. Your durable power of attorney can actually have both of these in there. Okay. But we like to separate them when we talk about them because you might have a daughter or a son who is in the medical field that you feel more comfortable making medical decisions for you. And that's typically what happens with a lot of my clients. I see them have a child who is a nurse and say, okay, they make my healthcare decisions. On the other end, they'll have a son or daughter who's an accountant. They make my financial decisions. Somebody who is good with your healthcare information might not be the person who's also best with your money. So that's why we separate, but they can all be on one document. There's a question in the back. Two questions.
Let's go here and we'll come that way.
If you have these attorneys and things, does this have to be in writing or is it just by word?
It has to be in writing. If it's verbal, it does not exist.
Does it have to be? What is it called? Notarized, or does it have to something else?
Yes. I will say this, there is leeway about notary, but I would always get something notarized. If not, then anybody can draft anything that said, hey, she gave me the right to make these decisions. So a lot of times you will see institutions require notary on those documents. And do know that these documents are not permanent. You are able to revoke them whenever you would like. If you have a falling out with someone and you feel like, okay, they're no longer able to make those decisions, or God forbid that person gets ill and you're like, okay, this person doesn't have the time, space, or capacity to help me anymore, you can revoke that document at any time.
My question is, I don't have any relatives here, and so my daughter-in-law lives in California, and she has all my paperwork. So if I got sick or something, should I give somebody else some sort of power of attorney?
That depends on two things. Her ability to get down here in case, or communicate with whatever facility you would want her to talk to. But if, in this case, you feel like she's in California, she can't really be accessible, then yeah, it doesn't have to be a relative. It can be anybody. You just have to make sure that you really do trust that person, and that's very important.
Do the documents have to be submitted to a court?
So no, not necessarily. I will say this, if you are creating a financial power of attorney that says this person gets to make financial decisions for me, I would turn that into all of your bank institutions. I would turn that into Social Security. I would turn it into whoever needs to know that information. also, if you're going to revoke that right, I would also contact those people and let them know this person no longer has that power. Same thing goes with healthcare. I would make sure if there is a specific hospital that you would give them that information. If there's your primary care physician, you get them that information. I know most doctors provide you with a HIPAA disclosure. And HIPAA simply says this person is allowed to have my information. It does not say that this person is allowed to make decisions for you. So it's important to have both.
Okay, you could have more than one person on your power of attorney, because I have one, but I have my son, my mother, and all my grandkids that get do so many percentage of things. So how does that work?
So you can have all the people in the world on there, but it's very important that you give everyone distinct powers. If not, it's pointless, because now you're at the hospital in that bed and the doctor's asking what to do, and one person's saying, do this. The other person says, nah, don't do that. And now there's a stalemate. Who gets the final say? You can specify, legal documents are flexible. You can specify in there who has the final say, who has the ultimate right. But then you also get into a complication where, okay, the person who has the ultimate right was not called or consulted about a decision that was made. So that's where it gets complicated. And you really want to designate one person who you trust to do those things.
So I gave everybody has a copy of my son, my mother. Like if my son
Oh, you
was
gave
to
them
pay,
copies.
yeah, they all have a copy.
But who's the person who is your power of
My
attorney?
son is the first person.
Okay, so that's another thing you see in a lot of these estate planning documents. If you give someone a power, you can have a secondary person who is a backup, a successor. So if I give power of attorney to this person, if that person is to pass away, then the successor power of attorney is this person. So you can do that, but you want to make sure that there's only one person acting as power of attorney at the time.
So to piggyback, as far as power of attorney, so if you have a power of attorney and there's two people, so I'll say my brother and myself, okay, and say he's listed, we're both listed. Should we say in the event that one is not available or one is not capable of making a decision, it moves to this other person, or?
You can put it like that. You could say in the event that so-and-so is not available, then it's this person, but you just want to make sure that they can't make the decision at the same time.
Right, so if
Yes.
if it's two of us and we're both in our right
Yes.
minds or whatever, there should be just one
Yes,
that makes
and
the
a
decision.
successor isn't necessarily only when the person passes away. It's also when the person is not available for any reason. So, but that person has no rights unless the other person is literally
rights.
unavailable.
Okay,
Yeah.
okay.
Okay. All right. So
Let me also say this. We talked about notarizing. If it's not notarized, let me just say, I had a person who, my coworker's husband died, and her mother-in-law came up with a document that she says she signed, the mother-in-law signed, but it wasn't him. And so because there was no power of attorney, or because there was no, well, she came up with a will that she said she signed. And so that's why she's been in court for 5 years. So how do you deal with that? I don't know, I guess.
we will hold that question until we get to the wills portion. That's a very important question.
great.
And so once we get to the wills section, we will kind of cross that bridge. The most important directive, or the most important thing that you can do regarding your medical health while you're alive is have a advance directive or a living will. This is more important in my mind than any power of attorney. This says, doctor, I do not want to be resuscitated. If we are in a situation where I have to be placed on life support more than 5 days, pull the plug. This says, I don't want blood transfusions. I don't want to have I don't want to assert any kind of organ donation or anything like that. This says This is what I want to do. Don't ask them. Oftentimes, when in the hospital and you are unconscious and life-altering decisions have to be made, even if you do have a health care power of attorney, if the other children do not agree with that person, if the other people in your life do not agree with that person now takes the blame and the guilt for making that decision for the rest of their life. Make the decision for them. Make the decision so they don't have to. Recently, a family friend, she collapsed, and she was in a coma for 10 days, and her husband had to make the decision to take her off of life support, and he could not make that decision. And he let her sit there and sit there and sit there. Family members going back and forth, take her off, keep her on, lost as to what to do. And this woman is an attorney, but she didn't have a living will. And so now that he did pull her off of life support, he has to live with the guilt of, well, what if I had enough faith? What if, I waited longer, like some of these stories you hear where, God did do a miracle and brought that person back to life after a year? What if your children don't have enough faith and they decide, let's unplug her and move on? You want to make that decision. You want to make the decision of, I want to stay on life support as long as I can, as long as financially possible. You want to make that decision for them. You do not want to leave that decision up to your family. It is the greatest love letter that you can give, is to say, hey, don't worry about it, I got it.
When I was setting up a living will, I asked the question, can there be an in-between between do or do not be resuscitated? And I was told no.
There can, but it has to be very specific, right? So I've seen, and I've done some, where we specify, keep me on life support no longer than 7 days.
Okay.
Keep me on life support only if X, Y, and Z. If this condition happens, then let me go. So you can be specific. Again, legal documents are pretty flexible, so you can pretty much say what you want to say. Again, it's important that when you make these documents that you do give copies of them to loved ones, your physician, and if there's a specific hospital network that is in your insurance and you typically use, you want to make sure they have it as well.
About the power of attorney. Now, when it's only valid while the person is alive. So when you're deceased, that paper is not any good. That is not any good anymore.
Yes,
No.
that's
Right?
crucial to know. These 3 documents that I've gone over are only as good as long as you're alive. Once you've passed on, they're useless. And just remember also with estate planning documents, you cannot enter into them if you are incapacitated. I've seen people who will say, okay, my mother has dementia, she needs an estate plan. No, she can't make any decisions. She doesn't have capacity. So these are documents you don't want to wait until, okay, I'm headed to the hospital for surgery. After I wake up, let me try. No. If you have an important procedure coming up, these are things you want to make sure you have taken care of. If you are diminishing in mental capacity, you want to make sure you do this while you have the mental capacity. Designation of guardian ahead of need. So if someone does become incapacitated and they did not give you power of attorney, how do you get those rights? How do you help them with their finances? How do you help them with their healthcare decisions? They don't have capacity anymore. They can't write those documents out for you, so they can't make decisions for themselves. Guardianship. You want to get guardianship of that person. Now, before you, God forbid you're ever in this position, but if you do, if just in case, you do want to make sure you've designated in your estate plan who you want to be the guardian of your person, who you want to be the guardian of your estate. Mind you, these people will still have to be qualified with the courts. The court's not going to just because you said Sammy can do it doesn't mean the court is going to agree with you. If Sammy has a bankruptcy, if Sammy has a history of theft, the court's not going to let Sammy run your estate. So you want to make sure you're picking people who are going to pass that bar. You can also list, I do not want this person under any circumstance to be my guardian of anything. He has sticky fingers, and he has a habit of swiping your card. Make sure you list it on there. Don't let Johnny be my guardian. And so I have a client right now who one of the sisters waited, and he was incapacitated. His brother was incapacitated, and behind everyone's back, she went and filed, and it went on for 10 years without any of them knowing, while he was in a home. So he's in a nursing home. The sister has guardianship of his person and estate. The other siblings don't know. That's illegal, but that's why I'm working on it. And she's collecting all his Social Security. She's collecting all of his benefits. He is a veteran. She's collecting everything. And the other siblings just found out. So you don't want to leave it up to chance who will be your guardian. Make the guardian designation. Now,
Okay, now, is there a difference in guardian, who's the guardian and who is the payee? Is there a difference?
yes and no. So payee is something you can designate through Social Security and other benefits on your own now. And you don't need to do any kind of estate planning to do that. There's actually quite a few things like bank accounts where you can designate beneficiaries or payees while you're alive and well. The only place where that comes into conflict is if someone does get a guardianship over you, they can actually go in and change who your payee is. So if you already decided that you want Jackie to be your payee because Jackie is financially responsible, but you didn't say who you wanted to be your guardian of your estate, and Johnny has gone to the court, filed, and he has no criminal history, he looks good on paper, but you as a family know he got sticky fingers. Now he's your guardian of your estate, and he's taken Jackie off as payee, and there's nothing you can do about it because one, you're incapacitated, and two, you never designated who you did and did not want to be your guardian.
How do you prevent that?
Designate your guardian.
No, like, say, if I was the guardian, somebody else was, appointed, like you said, for the estate, and then they could go in and change it, they could take it to court, right?
No, so the person who designates the payee is you. You designate the payee. Oh, okay, you're saying if you're the ward. So the person who is under a guardianship is a ward. Kind of like you hear ward of the state, you're a ward. And so if you're the ward and you've designated a payee and you want to make sure that somebody else doesn't come through and take them off later, you want to list, you want to make sure you list who you want to be your guardian of your estate now.
Did everybody hear the question?
So the question was, how do you prevent, as a ward, I'm assuming, how do you prevent somebody from going in and changing who you designate as your payee? And so, again, it's just making sure that you designate who will be the guardian of your estate and person now, and make sure you also list, and I find this to be more important, is to list who you don't want to do it. I think that's more important than saying who you do want to do it. List who you do not want to do it. Question?
Go ahead, finish.
No, that's it.
So if you're talking all of these different forms, is it one general form that we can use, or we have to have separate ones? And then on top of that, real quick, you was talking about accounts. So it's my brother and myself, I speak personally, and on my mother's account, he's on one, I'm on another account. So if anything should happen to her, we have access to both of her accounts. Is that?
So, okay, first things first. So this designation of guardian, this is something that can be a standalone document, but I typically will put this in your will or your trust. You don't need to have 50 million documents floating around. Now, your power of attorney, it can be one document, but your living will is separate. This designation of guardian, again, it can be its own separate document, or it can be part of your will or trust.
So if you have a will or trust, but you have one person on your savings account as the beneficiary, and then you have somebody else on your savings account as a beneficiary, and you have somebody else for whatever other savings or investments that you have, does that make a difference in who the guardian is and who the beneficiary is and so forth? And
No, so what you're talking about, and it piggybacks off of his question. So what you're talking about is called POD, pay on death benefit. So when you open a bank account, they ask you, so if you were to die, who gets your account? Designate whoever you want if you want to. Now, your hope and prayer is that that person is going to do what you want with that money. Because if you say that I'm sorry if anybody's name is Johnny. If you say that, Johnny's got his act together, so I'm going to go ahead and put him as my savings account POD, right? Okay, when you pass on, Johnny gets the entire account, which Johnny's got his act together, it's not a problem. Well, Johnny also has a lot of debt from when he was having bad behavior. And so despite you telling Johnny that you want each of your children to get this amount of money, his creditors got to get paid first. Yes, they do. So you want to be careful with POD. It is better that you let it go to your estate plan than to designate a person who you are not sure of their financial circumstances.
what is POD?
Your pay on death beneficiary. And that is what you're going to see in your bank accounts. It's different when we're talking about retirement funds, and we will get there. But when it comes to your bank accounts and setting your pay on death beneficiary, be careful who you choose, because their creditors can come after that money. And sometimes people are in hard times and they decide, well, my other siblings are better, they're doing better than me. Mom and dad helped them with undergrad. I didn't even go to college, so I need this money so I don't lose my house.
So also, if they're the beneficiary, they don't have to share that money if they don't want to.
No, it's their money. It's not they don't have, that's their money. Whoever is your pay on death beneficiary,
Yeah, so we
that's
just want
their
to make
money.
sure that you realize, just if you have 5 kids and you got 1 kid on there, that don't mean the other kids get anything.
No, they don't. That's not even part of your estate. That is their money. Same thing happens when you see people who have had multiple marriages. They'll put their spouse as their pay on death beneficiary on an account, and that's fine and dandy. But if this is money that you got before the marriage and you have children from another marriage and he or she is not so keen about those kids, they may never see that money. Or maybe they held that money to distribute later. But if they pass away, that money is going to be distributed based off of their estate, and your kids have nothing to do with their estate. So you want to be careful with how you make your decisions on who is your pay on death beneficiary. So let's talk about some common estate plan questions. So what if you don't have an estate plan? If you don't have a estate plan, the state will make a estate plan for you. The state has what we call intestacy laws, and it says if you distributed. So cold. Well, you better hope that those children are from that spouse, because if they're not, they get their portion. On top of that, if you have creditors, your creditors got to get paid first before your assets are distributed.
So how do you keep your creditors, how do you keep the deceased creditors from getting money and the other person getting money and that person is going? How do you do that?
You stay out of probate. So, what is probate?
All right.
Probate is a court process that determines who gets what and where. This is when a judge will appoint an attorney ad litem, and I serve as an attorney ad litem for the court all the time. They'll appoint me to go and dig into your business and figure out how many kids are there and who are they? Who are the heirs of this estate? You might have, this is an unfortunate common one that happens, is somebody has these children with their spouse, and then there's a mystery child somewhere. So, big surprise. So now we got to get DNA tests done. And now these children who they're, unfortunately I got to say daddy told, oh, you guys are all going to get this because, I need, there's the three of you and I made sure I put this money away for y'all. No, now it's getting split 5 ways. Now everything was supposed to go to your wife because all your children are of your wife, but that's not the truth. And in the state of Texas, if all your children are not from your spouse, your living spouse, then your living spouse is not going to get your estate in total. So you want to make sure that these things are spelled out in estate plan documents. But I don't know if you see this. It says, probate court is a process of determining whether a person died with a valid will. Wills go through probate. Wills go through probate. Wills make it easier to go through probate, but wills go through probate. If you spell out in a will that this is what I want to happen, your family still has to take that document to the court, say, hey, I want this house, I want this house, I want this account, I need all this transferred. Here is the will. We have to validate that will. We have to make sure that there's no contest to that will. Then, depending on how the language is presented in the will, your family might have to submit an inventory to the court before they're able to separate the assets. Your family may have to notify some people. So wills are not bulletproof.
Oh, my question is, we're going through probate. My son's father died in 2010. So his aunt contacted me last year and said that her aunt died and didn't have any kids, but she left my son and his other siblings everything. So they're going through probate right now. But it took them a year or two to find me in order to get in contact with my son, let him know that one his aunt he never met has him on the wheel. So it's like 6 of them that's on the wheel for probate and stuff.
That's often what happens. If you have no children and you pass away, your assets are your parents' assets. If your parents no longer are alive, they go to your siblings. If one of your siblings is passed away, then it goes to that sibling's heirs. So now you have a web of people you need to locate.
Can you say again what you said about wills? You said wills are not any good at what point?
Well, I'm not saying wills are not good. Wills simplify the probate process. Okay? They're first line defense, in my opinion. If you do not have the financial capabilities of getting a trust, if you do not have the financial capabilities of getting a trust, and if you don't have the time,
What do you mean, the financial?
trusts are more expensive than wills. 9 times out of 10, trusts are always going to be more expensive than wills. Because when you have a trust, you have to fund it. Funding a trust means that, and there's a whole section on trust. We're going to actually spend a lot of time talking about trusts. But when you have a trust, it's not good enough just to write, I want to give these things to these people, and these people are going to run these assets. That's not good enough. You actually have to, while you're alive, transfer those assets into the name of the trust. That's different from a will. A will just says, hey, when I die, this is who gets what. A trust says, hey, these things are now owned by this trust, and this trust dictates who gets what upon my passing. There are tons of different types of trust, but the trust we're going to talk about today is a revocable trust. Why? Because it's the simplest, and it's not permanent. You can change your mind anytime. It doesn't have the tax protection, but that's complicated, so.
Yes, is there an amount that triggers, an amount of the estate that triggers the requirement for a probate? Or is there certain things in the estate, sort of like a car or a house or something that has a title or something that requires a probate? And if that person has none of that, do you have to go through probate?
If, let's say somebody has been renting their whole life, and so you're renting a house, you don't even have any assets in your name, and all that you really have left is a box of cash under your bed. Your family can distribute that how they want to and move on with their lives. They don't need to go to probate. If you have a house, probate. If you have a car, probate. If you have money in a bank account that does not have a pay-on-death beneficiary, probate. There are different types of probate. We're not going to get into that because, again, very complicated. But there are things like small estate affidavits. If all the person owns is like one property and it's less than a certain amount of money, there's just a form you fill out. You submit it to the court. They might, depending on certain things, assign someone to investigate into it, and then you're good to go. It's still going to take time, but it's not going to have you in court for like 4 years. If nobody tries to contest it.
I'm trying to remember what my question was.
One there, and then we come to Faith. Got two more.
While you remember, I'm going to pass her the microphone. You're fine.
Hold on
You
a second. We're going to come right here first, and
Okay.
then,
Oh, okay, sorry, I
and
forgot.
then come to Faith.
Once you have a will, I'm sorry, how long does it take for you to have it probated? Is there a length of time
No,
that's required to have it probated?
you are supposed to probate a will within 4 years.
4 years? Okay.
If someone passes away, you have 4 years to probate it. There's exceptions. There's always exceptions in the law. Let's say you just found the will today and the person passed away 10 years ago. You can probate that will. There's little exceptions, but typically 4 years, you want to probate a will within 4 years. If the person passes away today, you can go today and take it to get probated. There's no waiting period.
I was going to say, I have a friend whose parent was left property, was willed to her, and the parent did not probate the will. Here's 8 years later, or however, and they want to try to sell some property, and it took 2 or 3 years for them to work through that process, and then the judge said he was just being kind to probate it, because he never probated a will after the 4 years. So, you know, it can be a real sticky problem. I just wanted to share that from her.
And to piggyback off of that, if we're going to be very real and transparent about it, America has its rules. Texas has its rules. And in this game of life, you have to play by the rules of the game to get far. What you see happen so often, especially within the Black community, is somebody dies, everybody stays in the house gets given to somebody else, but nobody ever probated anything. And here comes, and the worst is when they're not paying the property taxes, because the property taxes are in somebody else's name. And so here comes gentrification, here comes the government, and they say, we want to build this golf course. Time for us to call in all of our tax foreclosed properties. And now you're sitting there wondering how you're going to pay a $500,000 tax bill on a property that's not worth even $200,000 because people sat around for generations, didn't pay the property taxes, and never changed it out of great-great-great-granny's name. Even if there's no dispute, change the title to the property. Because if you don't do it, somebody generations later will have to. And it's going to cost them a lot more than it would have cost you.
Okay, now we're gonna do two more questions, and then we're gonna let her get a little bit further into her presentation. So write your questions down so we can come back to them.
This is a question, I think, I don't know, a question or some information. Does the probate work, I think I'm saying this right. Say, for instance, you have property or stuff that you want to sell. Does the probate will or whatever work for that? What procedures do you have to go through in order if you want to sell property or something like that?
So just to clarify, are you saying that if you put property into a will or a trust and you decide you want to sell it, what do you do? Or are you asking that if somebody passes away and they're willing something to you and you're in the midst of probate and you want to sell it, what do you do? Which question? Yes, that's what the latter? Okay.
Probate or it's your property?
Probate or will, however, how does it?
I'll answer both questions, actually. Even if you put something in a will or a trust, well, if you put something in a will, you can always give it away. You can always get rid of it. You can do whatever you want. When they read the will and they say that somebody gets the property on Main Street and the property on Main Street was sold 15 years ago, nobody gets the property on Main Street. Simple, right? It's still your property. You can do what you want with it. When it's in a trust, same thing to an extent. It's a revocable trust, and during your lifetime, you are during your lifetime, you have the right to take it out of the trust as you want and sell it. So also, same thing, you can do what you want. Now, if you're in the midst of probate and there is a property, this was happening a lot with clients since the pandemic, honestly, when it was a seller's market, a really heavy seller's market. As soon as a probate was filed and they saw that there was a house in it, you had realtors and all kinds of sharks calling the attorneys saying, hey, we want to buy this house. What can we do? We'll pay this. We'll do this. You don't have to wait till probate is over to sell it. You just got to get permission from the judge. There's paperwork you file, and you can go ahead and sell the property and then holds up the money in escrow until decisions are made about who gets what. However, everybody has to be in agreement. And if everyone's not in agreement, that doesn't happen. And I do want to caution you about leaving. If you leave a property, if you don't have a will and the property gets split between your 4 children, and one of them decides, I really need the cash, I really don't need this house, they can force the sale of that house. So be mindful of that. Not only can they force the sale of that house, if they don't force the sale of the house, they can force the other ones to pay them cash to buy them out of the house. So if you have a property you want to stay in the family for generations and X, Y, and Z, these are things you can kind of specify in a trust about the sale of the land, the sale of the property, and who gets it. There's just specific language for everything, and the more specific you want to be, the more complicated it gets. But you just want to make sure you have these conversations now with your family members and you're on the same page. Because if not, you never know what's really going to happen moving forward. And we've already talked about this, about adding someone on as a joint owner of something. One thing I've seen people do is they'll go ahead and add their children on as joint owner, like one of their children on as a joint owner of a house, and say, okay, I'm going to add my first son on. He'll get the house, and then, he'll distribute it when I'm dead, right? That's not how it works. He is a joint owner. You both own half of the house now, and when you pass away, your half of the house will still go through probate. Yeah. So you can't just add someone on as a joint owner. They're just a co-owner. You still own 50%. You own 50% now. They own 50% now. So your stuff still goes through probate regardless, unless it says this is a. It's called joint tenancy with survivor, something. There's some special language that we learned, but it's a certain kind of joint tenancy that if you pass away, the other person gets it out full right. But Texas doesn't really do that anymore. So you don't want to co-own something with someone, just try and skip out on probate.
Real quick, if I could just say, the church is going through a fast, but we do have a little coffee, a little juice for those who are fasting in different ways. If you got to have something, a donut. And we know we're going through a fast, but everybody's not doing the same fast, and so we do have some things in the back if you need something. We don't want anybody getting sick or anything like that, so thank you very much.
Okay. And we talked about this already, right? You can do transfer on death, pay on death, but just know you're vulnerable to that person's creditors. So if somebody owes a lot of money to the IRS and you do a transfer on death deed on your property, then when you pass away, that person automatically gets your house, right? But now the IRS has a whole bunch of liens on it, so that person now cannot transfer the house and split it with the other kids, nor can they sell it without losing the money that they owe the IRS. And child support. Child support liens are rampant. So if somebody has a mystery child somewhere that you didn't know about, but the government knew about and is adding up that child support, as soon as that person gets that property, they're going to slap on that lien for child support. So how do you avoid probate? You die with no assets being in your name. That doesn't mean transfer everything over. I think we already kind of spoke about this. Don't just say, okay, now I'm going to transfer this house over to this person and give this person that and tell them what to do. No, it's put your stuff in a trust. Again, it's not that wills are not valuable, they are valuable. I even challenge you that if you don't have any kind of estate planning, there's something called a holographic will, where you can just grab a piece of paper and write, I leave everything to Johnny, right? And you sign it, and that's it. It has to be in your handwriting completely. No stamps, no other type text on it. It has to be completely in your handwriting, right? This is a last resort, but it works, okay? A lot of ways people can mess that up, but it works. Make sure you have a lot of handwriting samples places too, because they're gonna have to testify to your handwriting. So that's also very important.
Does it have to be notarized?
No. That is the beauty of a holographic will. It does not need to be notarized. Don't notarize a holographic will, because then now it's not all in your handwriting. It needs to be completely and wholly in your handwriting.
Does it have to be dated?
You should date it. It doesn't have to be, but you should. I would just in case, have one of these laying around. No, it does not have to be witnessed. A holographic will is just a real old school Texas way of making sure you pass on assets in a last minute emergency.
My husband left a holographic will. And when I went to probate it, the court required 2 people to attest that it was his signature, and that was it.
So a lot of people in Texas back in the day, this is what they used to do. They used to just take a piece of paper and, you know, their little notepad and write, I, John W. Smith, give my assets completely and totally to my daughter, Clara, or to my son, James. And that's fine. Let's just make sure that you only have one son named James. Let's also remember that if you say to all my children, if you adopted a child after the age of 18, they don't qualify. There's little caveats here, and I've seen people who have raised children their whole life, and it was when that child got older that they're like, just for the benefit of, you know, the sentiment of it all, I want you to adopt me as your child. And so the person will go through the adoption process, and that person will be their child legally now. They've always been their child to them in their heart, but they're not entitled to anything if you don't have a will that specifies their name, because they're not your child.
So if you write it out at the last part of your life, does that have anything to do with if it's contested, the signature?
Oh, no, anything can be contested. Anything can be contested.
So
but
if it's notarized, is that better?
notarizing things make it better, but do not notarize a holographic will. Do not notarize a holographic will, because it no longer, once it has anything on it that is not your handwriting, it's no longer a holographic will. It's a failed will. And a standard will needs 2 witnesses. That notary has become your one witness. You're missing another.
What if you have some property and you have to have a cosign and you get the child a cosign? Does that mean half that land go to him or half will go to you?
So co-signing, that's an important question, because I know especially the older generations tend to do that a lot for their children. Now, are both people on the mortgage or on the deed? Because if what's on the deed determines who gets what. The mortgage only determines your debt. So you pass away, you have a will that says everything goes to X, Y, and Z. Well, you also co-signed on a loan for so-and-so. That is now the debt of your estate. And depending on the language in that mortgage, you can be liable for all or half. So again, this is why trusts are very important. And it's also why it's important to make sure if you're co-signing for somebody, you trust that they'll take care of what they need to do and do it correctly.
My brother and myself, I keep going back to my brother and myself. And my father is deceased. Okay, my mother's still living. So I used to, from what I'm hearing, and they had a will. So what I'm hearing is it best to do a trust for her, to put her stuff in a trust, or leave it, I mean, like I said, they have a will.
They have a joint will?
They had well, yeah, I guess you call it joint.
Was it one document for both of them?
Well, it listed their names separately, so I guess maybe 2 wills.
Separately on one piece of paper?
No, 2 different.
2 different papers?
Uh-huh.
Okay, and did
So
you
if
guys?
anything happens to him, everything goes to her. Mm-hmm. And, you know, and once,
And
you know,
vice versa?
vice versa, and then it goes down to my brother and myself. So from what I'm hearing, is it best to put her stuff in a trust now?
Did you guys probate your father's?
We're trying to finish it up. We're almost at
Yeah,
the finish line.
Put her
Because
stuff in
we've
a
learned
trust.
valuable lessons through this process.
Put her stuff
Probably
in a
about
trust.
2 years
Yeah.
that we've been trying to probate. And only because I think the way the will was written, it listed my brother as the first person that it goes to, and myself, and then my mother. So we had to get my brother-in-law had to sign over our part
To your-
to her. So that's the way hers is reading as well. So, well, now it doesn't matter because it'll be my brother and myself.
Oh,
So
true.
my father, he, you know,
'Cause your
right,
father
so
is-
he's on,
yeah,
right.
that's true.
Exactly.
Yeah.
But from what I'm hearing, a trust may be something that we need to do.
A trust would have saved you 2 years.
Okay.
Yeah.
And that's what, okay, and that's
Yeah.
what I'm hearing. Okay, all right.
But again, trust, you have to do the legwork of putting assets into the trust. You have to go to the bank and put first of all, trust has to, we'll get there. So we're talking about a revocable living trust, right? So now we've created the Smith Family Trust. There's going to be a trustee, which will be you. You are the trustee, you're the one who is in charge of the trust because you're alive. Then you'll have a successor trustee, who is the person who, when you pass away, is to carry out your wishes. The beneficiaries are going to be your children and you, right? Or your loved ones and you, right? Because while you're alive, you are going to benefit from the trust because it's still your stuff. So, So you're going to want to put your bank account in the name of a trust. In order to do that, your trust has to have an EIN. EIN, if anyone has ever started a business, they're familiar with it. It's an employee identification number. It's free, and it's from the IRS. You get one of those numbers, and you're going to use that to open a bank account in the name of the trust. And you're going to fund that bank account with the money that you want to be part of the trust. You're going to, if you have any real estate, you're going to go and actually change the deed to be put in the name of the trust because you technically still own it. There will not be any tax penalties or anything like that for doing this. Same thing goes with a vehicle. They have a specific place on the transfer paperwork at the DMV, or Department of Motor Vehicle, yeah, DMV, that for you to transfer your vehicle into a trust. When you create a trust, you're going to list out. I'm trying to keep it simple, but in the trust is going to list out who your beneficiaries are and what they get. Sometimes people specify who gets what, and then sometimes people just say, I want every asset that is part of my trust split equally. You do not put retirement accounts in a trust. This is very important. If you make the mistake of putting a retirement account in a trust, it will complicate your family's life. Retirement accounts have something, I can't remember the acronym, but it's like a minimum deduction, a minimum amount that must be withdrawn every year. If it's in the name of a trust, it becomes complicated because now who's withdrawing the money and where is it going? You can do the specific designation of it into the account, but if you've placed it to where once I've passed on, the trust is to disseminate, to pass everything on to everyone, and I'm no longer going to own anything, then now your retirement benefits are supposed to be on a regular basis by a trust that no longer exists. There are trusts that do stay and live alive, but those are for more specialized reasonings. And you don't go to probate court with a trust. The only time you'll ever go to probate court with a trust is in one specific way. If you fail to fund your trust with something, let's say you've been like, I'm going to put this house in the trust name next week, and God forbid something happens to you and you don't make it to next week, right? Well, there's something that we put in your trust called a pour-over will. And it says, in the event that any assets are still left in my estate, I want them to go to my trust. So now all that happens is your successor trustee will take your will to probate and have the probate court give your trust the rights to whatever else is in your estate. We would also put a no contest clause in it that says if anyone tries to contest this and they're unsuccessful, then they have now forfeited their inheritance. You do that just so you can kind of tell people, back off, chill out, this is what I want to do. Don't prolong this probate process unless you really feel like there's an issue. So, trust is how you avoid probate court. You put it in the will. Yeah. Oh, God bless you, thank you. Okay, so sometimes, the laptop is dying. Sometimes there's different ways in which you do trust because there's people who are needing special consideration. For instance, if you have minor children, you want to have a trust. You want to appoint them a guardian. You want to make sure that it's listed out that this is who I want to be their guardian if in any event I pass away. Additionally, minor children can't directly inherit large sums of money, right? So it goes in a trust. If you create the trust, then the trust will hold the money rather than giving it to your children, and the trust will determine how things are passed along, right? So what you'll see, for instance, is some people will have life insurance policies, and they will put their minor children as beneficiaries. And what happens is the court will say, well, they can't have that money, so we'll put it in a trust and we'll appoint a guardian for that trust, and that guardian will hold that money until they're 18 in a trust, or the guardian will use it to help take care of them, right? But you want to be the one who makes that decision. You want to be the one who says, I'm going to put my life insurance policy into a trust for the benefit of those children, and the trust is going to outline who is going to be the trustee who passes out the money to my kids, because I only trust my husband, or I only trust my sister. If your husband is alive, then obviously you would probably make your husband the beneficiary of your life insurance policy, right? But okay, maybe not. So, but sometimes what I'll see is people will put the beneficiary as their minor children and go from there. So, that's what I was talking about. Yeah, so you might have, and we call this a spend, in a trust you can have something called a spend-thrift clause, which says, okay, we know Johnny is bad with money, and we know Johnny has a lot of creditors, so we can't leave Johnny nothing outright. However, we can make him a beneficiary of a trust that manages the money for him and allows him to get a certain allotment of money each month that is exempt from the reach of creditors. So when you craft a trust, you want to take everything into consideration. Are there people who don't know how to manage their money? If so, you can still manage it for them from the grave. Same thing goes with blended families. I specifically was asking you about whether or not your parents had one will or two. A lot of times in the past, and sometimes currently, people make the mistake of putting both people into creating one will for two people, or creating one trust for two people. What you want to do is have everyone have their own will and their own trust, because if there are because of blended families, if there are some children that you want to get certain assets and other children you don't want to get certain assets, and you and your spouse might not be in agreement, it's important to have your own document where you can actually outline how you want to separate your portion of things. I had a client who, they're Nigerian, and in Igbo culture, everything goes to your first son. That's just what it is. That's just what it is. Everything goes to your first son. And the father, that's how he wanted his stuff written. He wanted everything to go to his first son. The mom, on the other hand, was like, but my last son, he hasn't got himself together yet. You know, he's still trying to get things together. I don't want him to get kicked out of the house by his siblings, X, Y, and Z. So she specified how she wanted things for her side of things. So you want to make sure that each person has their own trust, because depending on who passes away first will decide a lot of how things will go, at least with their portion of the community property estate. And I don't know if you've heard community property, but this is Texas community property law. Anything that was purchased or earned during the marriage is a part of the marital estate. Anything that was purchased before the marriage is your separate property. Anything that was inherited or gifted to you during the marriage is also your separate property. So you get to make decisions on how you deal with your inheritance, not your spouse. If you inherited some land out in the country when Granny passed away, that's yours, separate and apart. Unless you put your husband or wife's name on the deed, that changes things.
So on that property you may have out in the country, can, via the trust, you assign that property to, say, a child of yours, and put in there also that money will be set aside to pay the taxes or pay the this or maintenance fee for a year or something that goes to the companies and not the child, if that child is not fiscally sound?
You can. So for generations, a lot of the upper class white families in America run their families for generation through trust funds. And so what they'll do is they'll fund a trust, and they will have a trustee appointed that is a business or a corporation or a child that they feel like knows what they're doing. And that child who is in charge of the trust might be given rights to invest the money that's in the trust to create profits, and the profits from those investments can be used for the maintenance of X, Y, and Z. Trusts get complicated. The more assets you have, the more complicated it can be, and the more specific you can be about how things are managed. If you have a home in there and you want to make sure that there's certain money that is used to maintain that home and that person doesn't touch it, you need to make sure that there's a way for that money to continue to grow, right? So you might want the trustee for that account to be a corporation. That corporation is going to get paid, but they're also going to invest that money and grow it. And that's why you see a lot of these schools that have endowments, or there's grants or something with somebody's name who died, thousands of years ago, because people are investing that money, growing that money, paying themselves, but also taking care of the desires of the person who created that trust. And so trusts are really a powerful tool to set the precedent for how things will go for generations. Also, when it comes to like farmland as well, you can keep the property in the trust, give certain rights to family members to live, like for instance, it's called life estate. You can give a life estate to certain family members and say, you are entitled to live in this property for the rest of your life, but you'll never own it. This property will always be owned by the trust, and it will always go to the next descendant based off of this setup that I have. So trusts can be very specific, and they can be a very powerful tool to make sure the generational wealth is kept and passed on. Especially would have been helpful when it came to a lot of African American families who owned a lot of big farmland that passed on, and then somebody was just like, I don't plan on being out here in the country. I'm gonna just sell this and move on. So that would have prevented that from happening and allowed for that property to possibly still be useful without it being a burden. And it becomes a burden when you leave somebody property that they can't transfer, but you've left no way for the property taxes to get paid. Also special needs. So I have a son who has Down syndrome. And for him, he may not be able to financially earn for himself in the future, depending on the progression of his diagnosis. So what you have are special needs trusts. And special needs trusts say, rather than me putting the burden on my other children to care for this child in the future, what I want to do is make sure that there's a trust set up that allows for them to be cared for. Allows for them to be cared for despite my absence, and that doesn't prevent them from receiving the benefits they're entitled to due to their disability. If you have a child who has special needs and you leave them as part of your will and you give them a lump sum of money, they're no longer eligible for Medicaid, or they're no longer eligible for Social Security disability benefits because now they have too much assets. Yeah, so this is why you need a special needs trust, because there will be a trustee who's in charge of using that money to take care of any of their expenses, but your child will technically not own that money, and so they'll still be entitled to receive their benefits.
Other benefits.
Yes, because they don't own it.
Gotcha. Okay,
Yes,
the
they're
trust
just the
owns it.
beneficiary.
Okay.
The trust owns it. Business owners, if you own a business, what is your succession plan?
Excuse me, Ms.
Oh,
Blessing.
sorry.
Does that include seniors?
It does.
So like if we have a relative who's having mental issues, dementia, so if they
Yes, it does. Same thing goes with a ladybird deed. This is a little complicated, and if this is relevant to you, you can always contact me. But I can't remember how many years, but when it comes to Medicare, there's a certain look-back period in which if you transfer a property within a certain amount of years, 5 years, they can go back and get it. Additionally, if you die and you have property, they can claim ownership of it and do all kinds of stuff, right? What we typically advise is for people to create a ladybird deed. And a ladybird deed, which is named after Lady Bird Johnson, because again, the elite white people in this country have been doing these things for generations and figuring out how to keep their money and assets. So a ladybird deed allows you to state, I want to transfer this property to this person and this percentage upon my passing. You still own the house. You still get to do whatever with the house, but it will not be held against you for Medicaid and Medicare purposes, nor will they be able to come back and get the house afterwards, because technically upon your passing, it will pass on to your beneficiaries that are listed in that deed. Okay? Okay, we talked about it well. Hold on. What does it say? Pets. This is relevant for some people. If you have a pet, there's actually a pet in New York who is a multimillionaire, because his owner had no children. Her spouse had died years before, and she wanted to make sure that her kitty got taken care of. And so she set up a trust, and she put it to be managed by a corporation, and that company hired caretakers for her cat, continued to pay the mortgage on the house, the taxes on the house, and is making sure that that animal has a good life. This is important because a lot of people believe that when they pass on, their pet will just go on to the next family member. But what really happens is that pet ends up in the animal shelter. And animal shelters are packed. And upon being over full, if that animal's there too long, they will euthanize it, and then there goes, Fido. So if you do have a pet and you do care about it, and, I may not understand it, but my sister, she does. She has a dog that she loves with every ounce of her heart. And for people like her, this is an important option. This is important to make sure you make allocations for your pets in your trust. Then you also leave language in there for either you leave language in your trust for how that money is handled. So a lot of people, what they'll do is they'll put the money to go to an animal shelter or something of that nature, a specific charity or foundation. If that language is left out, technically, because you still own the money, and you're dead, it'll now be administered through your heirs. And if you are someone who has no children, no spouse, siblings have passed on, parents have passed on, there will be a letter that goes to your 5th cousin somewhere in Arkansas to come and collect the money from a relative that they had no clue existed. Again, wills are a first defense. They should not be the end-all, be-all unless you can guarantee, 1, your assets are few, your heirs are amicable, and they have the money to deal with lawyers, if necessary. If they are indigent, there are options, of course, through legal aid and different things of that nature, but wills should be just kind of like a just in case, a fallback, like, oh, I haven't got around to doing my trust, let me put this in place just in case. Just remember, people make mistakes, and there's a reason lawyers go to school for a long time. Well, okay. What you should do next. So, there is some paper that is going to go around that kind of summarizes a bit of, it's a good starter and a refresher for you to go over some information with your family. You guys are doing great work by being here, but it's people my age who really should be sitting here right now. And if you have nieces, nephews, sons, daughters, grandchildren who need this information, sit down and talk with them. Talk to them with that paper. That paper will kind of give you a refresher of what we talked about. And it also have my contact information on it. If you text your name and email address and the word legacy to this number, you can get a free consultation. We can sit down and actually go over some of what you need. We'll set up a phone call or a Zoom and talk about your estate and, well, you don't need this, you don't need that. I had somebody call me to talk about probate, and the probate is in a whole nother state, right? But I was able to give them some guidance on what they should do and who they should talk to. You may need to update your will. You may need to update your trust. It all depends, but reach out and we can actually go over what might be beneficial for you and what you might need next. Questions? My email address is also info@attorneyblessing.com.
Okay, I know how to do it, but how do they go online and print out this form, this will and power of attorney to have it notarized? Because some people don't know how to go online and print this out and type in what they need and stuff and then have it notarized and stuff.
You mean like if, let's say I make a will for
The form,
somebody?
yes, mhm.
So typically, it depends, right? If you're not in a rush, I'll set up a date and come over and I'll do it all for you. I'll bring the witnesses and I'll bring the notary stamp. So we can talk about that as well. And then, so I'll print it out for you. If not, then you could always, so sometimes I have clients who just don't have time to meet with me. I'll send them their documents via email. We'll go back and forth, make any changes that need to happen. I'll send it off to them. They'll print it off at a library, go to the bank, and see if they can get it notarized, or UPS or whatnot. But I personally like sitting down with my own clients and doing it myself. If an extra witness is needed, I'll bring them. Sometimes people don't feel comfortable with their family really knowing what is what. One thing I meant to throw in there, please make sure your family knows where your important documents and forms are. Typically, this is also information we put in the trust or in your will to let them know, hey, the original copy of the will is here. My Social Security information, benefits information is here. My bank accounts are here. You do not know the trouble that families go through just trying to locate bank accounts because so-and-so did not disclose their financial situation. There are a lot of times where if you have a life insurance policy or retirement benefits and you didn't leave a beneficiary on there, your family might not know about it and that money will just sit there. So you want to make sure, most importantly, that you do have these conversations and you let your family know where your things are.
We've got a online viewer wanting to know, how does a death by deed work?
Transfer on death deed?
They said death by deed.
I'm going to assume it's a transfer on death deed. A transfer on death deed essentially just says, if I am to pass away, this person automatically gets this property, and that person can use that deed to go ahead and register the home in their name. So that's essentially it. It is like a ladybird. There's slight differentiation. There's slight differences between transfer on death deeds and ladybird deeds, but it's very slight, and a lot of times people use them interchangeably. But I would say if Medicaid or Medicare benefits are a worry of yours, to do ladybird deed. For a ladybird deed? No, because it transfers on death. But if that person, if the house is not paid off and it's transfer on death deed, that person is taking the property conditioned upon the mortgage.
What if they died and didn't probate it, and there's property left? How do you still, it's too late? I give specific. My father passed probably 10 years ago, and I'm the outside child. So the property is still in his name, everything is still in their name. And the property was never probated because, you know, he remarried and all of those. So, but it was never probated, but I did inherit because I'm, you know, the fifth child. So is it too late to probate it?
So nothing has been transferred name-wise, right?
Nothing.
Yeah, it's not too late.
Oh, my.
It's never too late to probate. It can be too late to probate a will, but not too late to probate.
Oh, there's a difference.
Yeah. Wills typically have a 4-year expiration date on them, right? But probating, I mean, I had a client where we had to probate something for 2 or 3 generations because they just didn't probate anything. So we had to probate the great-grandma's estate, then the grandma's estate, then her mom's estate, in order for her to even get to her stuff. So it's not too late. And anybody can start the probate process. You don't need it to be in agreement with everyone else to start the probate process. Any other questions?
Yes, is there a time limit? I know you said something about you're going to be doing Medicare and you have some property. Is there a time limit or something like that you can't make any changes?
You're not supposed to, and I'm not like the Medicare or Medicaid person, so I'm not 100% on this. But typically you're not supposed to transfer transfer anything 5 years prior to your benefits starting, because they can reach back to it. So I wouldn't say there's like a time limit, but just know that anything that was transferred within 5 years of you starting your benefits, they can actually reach back to recoup their money.
They got a commercial on TV that talk about you can call in and do all this stuff yourself. So what is the difference between hiring an attorney to do it and going through have you seen that TV ad?
Oh, yeah.
What-
There's
so what is-
TV
what is
ads,
the
there's
difference?
websites. Let me be honest. If it's simple and you just need something done, you can get it. You can pretty much do it yourself, right? But that do it yourself, I can't guarantee it's going to be done right. So if this is why also when we do estate planning, we don't, how much you're charged depends on the complexity of what you want, right? Simple will is just that, a simple will. A couple $100 and you got a will, right? Because it's simple. You know you want to leave everything equally in equal shares to these people, and that's it, right? Nothing fancy about it. That person could probably go online and do the same thing, right? But they got to make sure they do it right. And that's it. You got to make sure you do it right. These documents you're getting online, these people who you're calling, these are not attorneys. These documents are not prepared by attorneys, nor are they reviewed by attorneys. And I think that review is probably the most important aspect of it.
Okay, I have a question. I stepped away for a moment. I know you said something about retirement. Like for me, I have federal retirement. And so everything I've put in my retirement package or in my paperwork percentages for who I want to have percentages and all of that. So I'm safe with OPM with that, right?
Yes, you are.
Okay.
And that's the best way to do it when it comes to retirement benefits. Specify within the benefits who gets what and how they get it. Okay. Retirement benefits, again, those are things that want to be quickly dispersed and do not want to sit around waiting for people to come of age, and pick who you want to get it and where it's going to go.
So can kids get retirement benefits from their parents?
Minors?
No, older kids.
Yeah, they can. You can place them as your beneficiaries. Yeah, they can. I mean, upon their parent passing away.
Okay. But you did say do not put your retirement benefit in your trust?
Correct. Don't put your retirement benefits in your trust because upon your passing, most revocable trusts, upon your passing, what it says is for the trustee to distribute everything out and to dissolve the trust, right? Again, when we talk about more complicated trust, is when we talk about the trust to stay alive and pass benefits on to different generations and all that stuff. But a typical standard revocable trust, upon your passing, the successor trustee will pass things on to your beneficiary and close out the trust. Retirement benefits, the way those typically work is they're doing specific distribution at a specific amount of time. So if the trust is no longer in existence, then who's getting the next year's monthly payments for your retirement benefits? So the best thing you can do is go ahead and put the names of the people who you want to get those benefits and in the percentages that you want them to get it, so that way the insurance company can, the retirement benefits people can just deal with getting them their money and paying it out. And it's not sitting in an account that is not for a trust that doesn't exist anymore in hopes of us figuring out how we're going to distribute it despite the trustee being discharged.
Okay, so that's designated by your beneficiary? Is that with your retirement?
With your retirement, you want to designate your own beneficiaries through your retirement plan. And typically when you do a retirement plan, they'll ask you who do you want to get your benefits if you're not alive by the time that they're vested or if you pass away before they're completely paid out. And you want to list those individuals. You don't want to put it into a trust.
like a retirement fund or a life insurance policy, do those beneficiaries that you've already designated, they supersede anything in the trust?
Ask the question one more time.
Okay, say I have a retirement fund that my retirement is through the city that I work through, and so I get an allotment every month. I have designated who my beneficiaries are, or my insurance policy I've designated. I thought those would be the same no matter what the trust might say.
Yes, so the point is to not put your trust as your beneficiary. Insurance policies and retirement benefits are non-probate assets. These assets do not go to probate unless you fail to list a beneficiary. If you fail to list a beneficiary, then the money goes to your estate. Your estate has to be probated in order for it to be distributed, right? Unless, again, you have a trust that has a pour-over will that says, no, it still has to be probated. It's going to be probated through the pour-over will. So the point is, do not list your trust as a beneficiary to your retirement benefits. Insurance benefits, it's fine. Why? Because insurance typically pays out as a lump sum, right? So upon your passing, it's going to give all the money to the trust, and then the trustee will distribute it amongst the beneficiaries. But the retirement benefits, again, that is a trickling payment. And if the trust no longer exists, who gets the money? So that's the point.
Okay, hold on one second.
When you have investments, and just the spouse's name is on there, like, my husband passed and we had investments. So I think they were all there in his name, some of them. How do I go about getting these, investments, or how do I go about the money coming to me? How does that work? I mean, it's this. I know it was part of me, but it's in his name, and not mine. My name is not on there. So, how do I get these investments?
So in the state of Texas, again, we have community property laws, right? So even though these investments were made during the marriage with community assets, right? They're still, and they only have his name on it, they're still rightfully yours as well. However, because his name was on there, he has the sole right to manage it. So if you buy a car with your husband and it's time to sell that ar, your husband and your husband's name is the only name on that car, he's free to sell the car without consulting you. Because technically, his name being on there by itself meant that he is the rightful decision maker about that item. If both of your names were on there, then you also could make a decision.
What if he's passed?
So in a situation where he's passed away, it depends on the company that the investments were made with. Sometimes you can simply give them the death certificate and they'll say, okay, we'll take this, that's fine. You give them a death and marriage certificate, they'll accept it and they'll go ahead and hand it over to you, right? You see this sometimes with banks. Some banks are like, okay, well, you're the spouse, that's fine, you can take it, right? Sometimes they will make you go through probate. And again, probate, there's so many different types of probate, but in this case, you would need an affidavit of heirship. And this affidavit of heirship would list out who his heirs are and what portion of his property they're entitled to. And so it would say, community property, 50% of his 50% share of community property goes completely to his wife, right? Or if he had children from another marriage or from before or after the marriage, then it would be his 50% share of community property would half or 1/3 would go to his wife, and then the other 2/3 would be split equally between. So You can try, I would first try by giving them a death certificate and a marriage certificate. If they do not allow that, then you would need to do an affidavit of heirship through the probate process.
My question is that, who's in charge of the trust? How do you change your trustee?
You are the trustee during your lifetime, right? That's the beauty of a revocable will. A revocable trust. During your lifetime, you are the trustee. You are the one in charge of it. You are the one who determines what happens to everything. That's why it's revocable. When you pass on, you'll list your successor trustee who will handle it when you pass on. Now, you can put clauses in there for the beneficiaries to vote together and remove that trustee if they feel the trustee is not, doing what they're supposed to do fiduciarily and all that stuff. So it depends on the language you put in there as to what happens to the trustee and how the trustee gets chosen and X, Y, and Z.
I have a question about heirship affidavits. We have my family have 130 acres in East Texas. My great-grandmother owned it. All her kids are deceased. All of my dad's siblings are deceased and cousins that inherited. We do the heirship of affidavit, and someone passes away, so we have to redo. But we can't, it's several heirs on there, maybe 30. But we can't find any, we have a hard time finding an attorney to take it. Once they realize how big it is, then they kind of back off. So where do we go from there?
You still need an attorney. You still definitely need an attorney.
Yes.
The court needs to assign an ad litem, and that ad litem needs to verify and check that it works. The reason why attorneys don't want to touch it, if I'm being honest with you, is you're talking about a big spider web of individuals. Because if it's your great-grandmother's land, then they need to locate every heir of your great-grandmother. So that means they have.
We have.
Okay.
And
then all of them have to sign waivers. Are they all willing to sign waivers?
They are willing to, but we keep having to do the heirship of affidavit because people keep passing
on.
away.
Well, I can talk to you about that after, but yeah, it's sticky when there's a lot of heirs, and this is again why you want to take care of things right after someone passes away, because then you're stuck going back how many generations. As people pass away, you have to start doing it again. And the issue also with dealing with 30 people is who's paying for the attorney, So,
yes, it comes, we have it where we have a fund that it
okay, perfect.
that it
So
comes out of.
you should be able to find an attorney who is willing to take it. It's
Taxes are up to date, so
yeah,
that's not an issue.
it shouldn't be too difficult. It seems like you guys have already done all the legwork.
And I'm not the one that actually, my brothers are actually handling it, but it's just, my sister was handling it, most of it, and she passed away. So it just kind of, it's just
Keeps
kind
having to
of
get
like a
updated.
circle.
Yeah. Again, this is why you want to handle things when someone passes away initially, because even she's actually very lucky that she's been able to locate everyone. I have so many clients who it's almost impossible for them to find all the heirs because they just don't know where to start. Oh. Oh, no. Any other? Oh, she remembers.
Yes, yeah, I plan to call you because, I need help. Oh, yes, will your recommendations and all take into account how to eliminate a lot of the tax burden that would go with this stuff going to other people?
Yes, if it's necessary for your estate, right? Some people, it's just not worth doing that level of legwork to avoid the taxes associated with transferring one property. But if there is a lot of potential tax liability, if there's a potential of going over the gift tax limit and all of that, then yeah, these are conversations that we'll have. And one thing we do like to do, especially if our client has a really big estate, is we like to loop in a CPA. We like to work with an accountant who can also kind of go over, okay, well, this is going to be an issue for you. This needs to be taken care of now. I would leave that for the next generation. I'm going to recommend that you put this instead of into that. So the depth of the conversation depends on the depth of the assets that are there. You sound like my mom. Any other questions? So my office is mostly virtual. We do have office space out in Cedar Hill, Grand Prairie, and Arlington.
Can you meet them if you need to?
Yeah, so if necessary. So if per consultations, preference is always going to be for us to do, especially because it's a free consultation, is going to be over the phone or through Zoom. If that's an issue, we can do one of two things. We can either come and meet you at your home, or if the church would want to, we can also set up like maybe an office hour where I come here and we can like do little one-on-ones or whatever. It really just depends, but we can kind of tackle each person individually. Any final questions? Okay, so thank you guys so much for taking this time out to listen. Remember, you guys are leaving a legacy of love. Please do this so that future generations, one, you're laying the foundation of what the right thing is to do moving forward, and two, you're making sure that you allow people to grieve without any burdens on their shoulder. So, thank you guys.
Let me give an expression. Wow. I had no idea. I thought I knew a little something, but apparently I'm going to have to go back to school. Because a lot of that information, I had no idea. Great questions from the audience. Good questions from people that's online. I am just overwhelmed with the information that we've been given and the fact that God sent a blessing by bringing Miss Blessing to us. Will you have time to answer questions afterwards?
Yeah, I can stick around.
Okay, she'll have questions after. Yes.
So is there going to be a part B? Right. Because this is way more information. I mean, it's just too much to gain in one section. We got too many questions.
We definitely can work on that and get it out. It'll probably be a couple of months because we have to go through protocol. But if there's a need, then the Ministry of Hope would love to do that. Okay, great.
Maybe we could have a session just on one part of it instead of so much information at once. Maybe we could have another conversation.
Okay, but finding out which part that would be is already hard. Yeah, great. I think it's again. I just praise God. I just I was praying. I was like, God, we need somebody that's gonna give us the information we need because when New Year's came and they showed the list of the people that we lost last year in the church. Oh my goodness, I was like, okay, God, we need somebody that can talk about the issues that we have coming up. And so, hey, we've been blessed with blessing. Great, yeah, been blessed with blessing. Two things. If you didn't get a flyer, we have some extra ones. We're going to see if we can put some flyers out for tomorrow for people who did not have the opportunity to attend. And I'm going to see if Ms. Blessing can email me the PowerPoint. Yes, thank you. The PowerPoint that we can get printed out, and if you need it, then you can contact, I'm going to put Rachel on the spot. You can contact Rachel and she can make sure she get it to you. Okay, so if you need that PowerPoint. Yes. Oh, and it's online. Okay, so, and that's Facebook? Is that on Facebook? Yeah, okay, so you can go back on Facebook and rehear it again if you need to. This technology thing, it wears me out, I tell you. Kirk been trying to work with me, but he ain't doing a good job. Again, we want to thank Ms. Blessing. I mean, oh my goodness, what information. We also want to say that that if there's anyone who is not a member of Mount Pisgah that would like to be a member or is in need of prayer, then please let us know afterwards, and we'll make sure that we get that done. Okay, if you're interested in being a member, or if you need a special prayer, then we'll make sure we get that done. And so we're going to do a closing song, and then we're going to have a closing prayer by Deacon Curtis, and then we're going to go home and soak up some of this information. All right?
Well, what a great forum. Thank you so much. And also, we want to thank our minister, our leader, the Caples, Rod Caples and Monique Caples, and Sister Judy isn't here, and Pearl Lee, and everybody. And thank you all for attending. So this has been a great, forum, I tell you. So, yeah, I agree with you, Sister Sheila. We need to do more. So, can you all stand with us? How great is our God? We're going to close out with that song. He just asked us to do a closing song. How great is our God? Sing with me, how great is our God? For all to see how great is our God. How great is our God? Sing with me, how great is our God? For all to see how great is our God. Hallelujah.
Praise God. Thank you again, Sister Blessing. Just real quick, Sister Monique just said, my father passed away, it'll be 3 years in February, just in February the 8th. He did a trust. It took me a while to convince him that a trust was needed, because as African Americans, we generally don't understand that. But as our white counterparts have been doing it for years and years and years, it made my life, my sister's life, so much easier, because as we go to the banks, we're able to do business. We're able to handle the real estate. Everything is done because he trusted us. But you have to trust somebody to be in a trust. Now, it took him a while because he was a little older. He's like, why do you have my debit card? You trust me, Daddy. Remember, you trust me. And so it took him a moment. But again, I encourage us. Again, a will is a great thing. That's at least a start. But consider what Ms. Blessing said. To get a trust, you have to pay. It costs a little bit. I'm not going to act like it doesn't, because you're transferring things in advance.
but you're trusting someone to do what you can no longer do for yourself when that time comes. I think I can almost teach this seminar because, like say the Medicaid, if you ever have to go to a nursing facility, you need to start 5 years in advance transferring things out of your name because they want to get paid. They deserve to get paid. It costs to take care of us in our old age. So you have to just think about that. So I encourage all of us, keep doing these seminars, but keep reading, but call that young lady. Get a consultation. We can't get it all here, you guys, because every situation is different. You got to pay a little money to get good advice. That's why our white people do better, because they pay somebody to get good quality advice about their situation. We can't do it in a general forum. So now, with that said, that's my encouragement. Call her. If not, I have another good attorney that I can refer you to that I use that has been a blessing to my family. So let us pray. Lord God, we are so grateful, thankful for this great information, God. You always know what we need when we need it the most. So, God, we thank you right now for this attorney blessing. God, continue to bless her life. Anoint her, guide her, and give her the right people in her pathway, such as ourselves who are Christians, believers, that trust you, God. But God, give her the wisdom and the knowledge and the discernment to help us, to help her people that look like her melanin in her skin. But God, that she will be blessed financially because we don't mind paying for good advice, good wisdom, good understanding, good direction, God. We pray that you anoint her business in the name of Jesus. God, give her an overflow of what she needs, God, because we need to pour back into those who have studied, who have endured, who are trying to make the right decisions, God. So we anoint and thank you for her life. And in the name of Jesus, God, we pray that we all will go forward, because we know that we're only traveling through. As even my own family told me when I was asking about this and asking about this, they said, you'll figure it out. So God, we pray that in the name of Jesus that we make wise choices while we're living. So we anoint and thank you right now that we won't be afraid of this subject. Be afraid of that. This is only temporary on this side, but somebody's got to deal with it, God. So we pray that we'll put the measures and the things in place that make sense and make reasonable sense. So God, open our minds and our hearts not to be afraid to make those hard decisions today for tomorrow. Because when tomorrow comes and we're not here, God, somebody's got to deal with it, and somebody's got to endure that time. So we love you, and we thank you for the Capos having a willing heart to open up to our church, God, and wanting us all to be more thoughtful about tomorrow. So God, in the name of Jesus, I pray that we'll go forward today excited, even though we think about death. But guess what? We can get excited because we know our heavenly home is with you, Lord, and that one day all of this stuff on this side won't matter anymore, because God, we'll be in your precious sight, and we'll just pray that you'll say, well done, thy good and faithful servant. Come on up a little higher. So God, we just pray that we'll go in peace and travel this day and just always keep you close to our heart. In the name of Jesus, we pray today. Amen.